Hello and welcome to some more Star Citizen. There's been another couple of minor updates to the Crytek v CIG Star Citizen lawsuit that I thought is worth updating you on, with the understanding that I'm not a lawyer. Recently, YouTuber Laws Leah Lesser covered Crytek deciding to not further change their second amended complaint. In that video, he surmised that although the meat and main parts of Crytek's claims were dismissed and their lawsuit was effectively dead in the water, that CIG could still settle for a token amount, suggested to be up to 150,000 or so. The reason for that is that lawsuits are burdensome and expensive to both sides, even if it's just minor complaints or something that can be easily proven. Up till now, we've just been in the mega early phases of the lawsuit. Crytek have been pushing for a huge amount of information from CIG for discovery, the discovery process being where both sides can request information from each other and they are compelled to give it. This does also require, I believe, the court to agree to what is reasonable to give, though, in discovery, but that is quite burdensome and expensive, and this is likely to be a posturing tactic to leverage a settlement, asking for so much information. One of the major reasons now that Crytek would want to push for this is that they've already probably paid a lot into this case and lawsuit, and if the entire case went in CIG's favour, which it looks like it might, then they could be also liable for CIG's expenses. However, typically getting these remedies paid can actually prove hard and lengthy, and there is no guarantee that they would even get awarded this, so it might be in CIG's best interests just to settle. It would save them a lot of money. I know a lot of Star Citizen fans will want CIG to fight and to try and get their money back, but what is best for the company and game may differ from what you feel is right. It's obviously they operate as a business and they need to work out what costs more and what's sensible. Check out YouTuber Law in the description and the links below. He has a whole playlist on the subject of Crytek v CIG. Now, more recently, on the 6th of February 2019, CIG filed a document meant to clarify their position and fully answer the second amended complaint. It basically goes over all the points of the second amended complaint again and states that they are developing Star Citizen and Squadron 42 and they originally used the CryEngine, but denies any wrongdoing or breaking their contract or infringing on Crytek's IP, and in fact states that the GLA in common language supports what they've done and just general common sense supports all their actions. So the allegations that they've responded to in the second amended complaint are: defendants are developing a separate game using Crytek without permission. Defendants removed Crytek trademarks and copyright notices from their games and marketing materials without permission. Defendants broke their promise to not compete with CryEngine by adopting and promoting a competing game engine. That's the one that's been dismissed pretty much in its entirety. Defendants broke their promise to collaborate on CryEngine development. Defendants disclosed CryEngine technology to third parties without permission. So some interesting bits about that. CIG also go on to say that with the collaborating with Crytek on bug fixes for the engine, defendants aver that on or about the 23rd of January 2018, approximately 6 months after receiving Crytek's request, defendants delivered their bug fixes and optimizations to CryEngine as a complete compilable version. So they basically say there they have delivered bug fixes now, and if that's what Crytek wanted, now they have that. At the end of the document, there are CIG's affirmative defences. So this is a list of facts alleged by the defendant that, if proven, defeat or mitigate the plaintiff, or in this situation, Crytek's claim. I'll quickly go through these as I thought they were quite interesting. Failure to state a claim. The second amended claim fails to state facts sufficient to constitute a claim upon which relief can be granted against defendants. Express license. The GLA or Game License Agreement expressly permits the conduct of which Crytek complains in the second amended complaint. No breach. Defendants performed all duties owed to Crytek under the GLA other than duties which were prevented or excused by Crytek's actions or inactions. Lack of privity. There is no privity of contract between Crytek and RSI, as RSI is not a party to the GLA. Prevention of performance. Crytek prevented defendants from performing under the GLA by refusing to accept defendants' tender of its bug fixes and optimizations to Crytek pursuant to the GLA. Non-intentional breach. to the extent defendants are determined to have breached any provision of the GLA. Any such breach was not intentional, and therefore no damages are recoverable under Section 6.1.4 of the GLA. Implied condition. Defendants' obligation to display Crytek's copyright and trademark notices in Star Citizen and its related space fighter game Squadron 42, or their related marketing materials, is subject to the implied condition that defendants are actually using CryEngine in Star Citizen and or Squadron 42. And obviously that's a major point of contention because they're now using Lumberyard. Copyright preemption. Crytek's state law claims for breach of contract are preempted in whole or in part by federal copyright acts. Fair use. Crytek's copyright claims are barred in whole or in part by the fair use doctrine. Failure to register. Crytek has failed to register the copyrights in one or more of the versions of the CryEngine computer program it alleges defendants infringed, and thus is not permitted to file this suit or maintain this action as to those unregistered works. Invalid subject matter. To the extent that parts of CryEngine, Crytek's purported copyright work, constitute facts, ideas, or scenes of fare, such parts lack copyright protection and cannot form the basis of a copyright infringement claim against defendants. Merger and de minimis doctrine. Crytek's copyright claims are barred in whole or in part by these doctrines, which limit the scope of copyright protection. No statutory damages or attorney's fees. Crytek is barred from claiming statutory damages or attorney's fees under Copyright Act because all alleged acts of infringement began before first registration of Crytek's copyrighted work. Failure to mitigate damages. Crytek has failed to take responsible steps to reduce or minimize its alleged damages. It then goes on to say that Crytek's claims are barred in whole or in part by doctrines, latches, unclean hands, waiver, estoppel, and the claims are not ripe. So lashes is the unreasonable delay in making a legal claim. Unclean hands states that a party who is asking for a judgment cannot have the help of the court if they've done anything unethical in relation to the subject of that lawsuit. Estoppel prevents a party to a lawsuit from asserting a right or fact that is contrary to their past conduct or previous allegations. And ripeness basically says that some of the claim may rest on future events which might not occur. So why are we talking about it, sort of thing. But yeah, that's sort of like the multitude of defenses that CIG will put forward as appropriate to different parts of that kind of lawsuit. From here, we are likely to see either a settlement or a schedule for discovery go forward, which would then say, these are the things that Crytek want from CIG. As we've previously stated, though, it's looking very good in the sort of like position of power and on balance for CIG. I will, however, update you on anything else that pops up with the case in the future. Every month we have a Star Citizen ship giveaway. For February, it's for a Cutlass Black and Star Citizen game package. All you need to do is be subscribed to the channel and comment on any of my videos made during the month. If you don't have a gaming PC yet, or you are upgrading, instead consider Shadow Cloud Gaming. They allow you to leverage the powers of the internet to stream a high-spec Windows 10 environment to any other PC, Mac, or device like a smartphone or tablet. It is working really well in Star Citizen's 3.4 branch, and be sure to use the code BoredGamer if you do decide to check it out to get a discount. Links below. This channel exists because of its community. If you wish to support the channel further, below there are links to Patreon, Subscribestar, and there's the YouTube channel memberships, literally the join button below this video. VIPs do get some exclusive stuff and early content as a thank you as well. If you have any feedback, suggestions, or just want to say hi, please drop a comment below or poke me on discord.gg/BoredGamer. Thanks for watching, and I'll see you in the verse.